Good afternoon, everyone, and good morning, depending on where you are.
مرحبا بكم جميعا، صباح الخير ومساء الخير أينما كنتم. اسمي صابرين، يعني المديرة هنا في المجلس نورا الصبري. أنا كما قلت نورا صبري، وأنا هنا عضو في مجلس المعهد البريطاني هنا في تعلق في المعهد الملكي للمحاكمين القطريين، وأتكلم هنا عن عملية اتفاقية الاستثمار الخاصة بمنظمة التعاون الإسلامي. دعونا نبدأ فيما تكلم عن بعض المجموعات. لذا رجاء هذه زملائي الموجودين معي والمتحدثين أيضا رجاء الشريحة التالية. نعم هنا نحن بقرابة يبدو أننا مؤسسة جديدة أسست عام 2018 ولدينا 15 عضوا، وأيضا من الأعضاء المحليين أكثر قرابة من 322. أيضا فيما يتعلق ببعض المؤسسات الدولية والقضائية لفض المنازعات. رجاء أنا أريد أن نعرف وأخبر زملائنا أن يضغطوا بالقناة اللغة العربية، الضغط على أيقونة الترجمة.
Because somebody's asking. Thanks so much.
Yeah. All right. Thanks. So I thought I want to touch about it after this, but it's fine. Yeah. Thank you. So, okay, that's about it. And then without further ado, I'll introduce our moderator for today. So today we have Andrew Sims from Al-Tamimi and Company, based in Qatar. So Andrew is a partner and also head of construction with Al-Tamimi and Company. So just a bit of background about him. Andrew has for over 30 years specialized in all aspects of construction and engineering law, both in the relation to the contentious matters as well as project and procurement documentation. Throughout his career, Andrew has worked across many different jurisdictions, and he has worked in-house and has broad commercial experience at the highest level across multiple sectors. Andrew also has a wide range of contracting experience, particularly in relation to the legal and commercial issues surrounding the delivery of large projects on time and also cost. And obviously, Andrew has extensive experience in respect of all forms of international dispute resolution, especially arbitration. And last but not least, I would also like to highlight that Andrew is identified in Chambers and Partners and the Legal 500 Legal Directories as a leading individual for construction law, projects law, and engineering and energy law. So I'll pass the floor to Andrew to introduce our speakers for today. Over to you, Andrew.
Thank you very much, Nurul. I think we're all very much looking forward to today's presentations from two experts in their field. Before introducing the speakers, I thought it might just be useful to put it in investment treaty arbitration into a bit of a context, because it is quite a new area, certainly in terms of legal history. Just by way of example, arbitration has certainly been part of the English landscape, dispute resolution landscape, for a good 400 years, I would say. Then the Chartered Institute of Arbitrators itself is at least 100 years old. However, investment treaty arbitration really has been a relatively recent development, in that the first, I think it's recognized that probably one of the first investment treaties was in the late 1950s between Germany and Pakistan. So in legal history terms, we're talking about something which is very, very new, and therefore it is very, very useful for the Ciarb to have introduced this as a topic, and particularly from the Qatar branch. So having provided that little bit of introduction, to turn then to our two speakers. The first speaker today is Robert Volterra, and Robert is going to be talking about treaty arbitration in the Middle East. Robert is very much a both counsel and arbitrator. but as his title says there on the slide, he also comes at this issue from an academic perspective. He's a partner in a law firm, Volterra Fietta, but also a visiting professor of law at University College London, and is speaking to us today from the UK. Robert's areas in expertise in relation to counsel has been in cases before the International Court of Justice, the Permanent Court of Arbitration Tribunals, and also investor state arbitration tribunals. As arbitrator, he's been appointed by both investors and governments. And has been very much a part of the International Centre for the Settlement of Investment Disputes. Our second speaker is Professor Martins Paparinskis. Martins comes very much from the perspective of an academic. He will be speaking about the Organization of Islamic Cooperation Investment Agreement, together with generally discussing settlement of international investment disputes. As an academic, Martins has published widely in leading journals. He is cited regularly on issues of international law, and is also a member of various prestigious international bodies, including the United Nations International Law Commission. He's a member of the Permanent Court of Arbitration, and is a conciliator in the OIC Court of Conciliation and Arbitration. So those are our two speakers. I think we're all very much looking forward to their presentations. So I hand over now to Robert for his presentation on treaty arbitration in the Middle East.
Thank you very much, Andrew, for your introduction. And my thanks also to the Chartered Institute of Arbitration Qatar branch, and Nurul, who opened proceedings for us with her welcoming remarks. And also to Saad for organizing much of this along with his colleagues. And thank you all for joining today. I am looking forward to this very much. I was involved as counsel in my first investment treaty arbitration at ICSID 30 years ago, and I have been doing this work ever since, as Andrew said, for investors, for governments, sitting as arbitrator in cases, and I had the pleasure of teaching it as well. I enjoy the area of law, and I look forward to questions at the end of my and Martins's presentations. Next slide, please. And next slide, please. With the overview of my comments today in the 20-25 minutes given to me are set out here. I will provide an overview of what is the international law of foreign investment. I will then move into a brief history of investment disputes, including investment treaty disputes in the Middle East. It's a long and distinguished history. And the Middle East has been, including the Gulf, has been at the forefront of many of the developments that have led to the modern conception of investment treaty arbitration. I'll then have a look at the jurisdictional, substantive, and dispute aspects of investment treaties. Then I'll look at the modern era of investment treaty arbitration in the Middle East, and finish up with a few thoughts talking about what the future may hold for investment treaty arbitration in the Middle East, which I hope will be a good springboard then for Martins's presentation, which will focus, amongst other things, on the exciting developments coming out of the Organization of Islamic Cooperation Investment Agreement and the dispute resolution provisions now available increasing proliferation to lawyers who are practicing in this area. Next slide, please. Therefore, I will start, as I said, with an overview of the status of international law relating to foreign investment protection. Next slide. When we talk about BITs or BITs or investment treaties, we are talking about public international law. Public international law is the law that governs relationships between countries. It includes things like war, peace, treaties, the United Nations. All these things comprise public international law. So you may say to yourself, what relevance does this state-to-state law have to do with investors, foreign investors? And what does it have of interest to you as commercial private practice arbitration lawyers? Well, quite simply, because international law imposes obligations on states, both in relation to each other and how they treat each other's nationals and the property of those other countries' nationals. And these obligations are at the state-to-state level of public international law. Therefore, a country must treat foreign nationals within its territory in certain ways that respect their life, their liberty, and their property. And the law that applies to how a state can behave towards a foreign national is public international law, at least at the state-to-state level. There may also be domestic law that applies, but just because domestic law applies doesn't mean that public international law does not apply. So, for example, if a foreign investor from country A makes an investment in country B, and the government of country B expropriates the property of the national of country A, there may be some domestic law of state B, of country B, that applies. There may be court proceedings that the investor can pursue for compensation. There may be rules about the compensation given. That's one thing. But entirely separately from that, State B owes State A, under public international law, certain obligations of how State B treats the citizens and the property of State A. And so regardless of what there is in domestic law, there will be some minimum standards and obligations that State B owes to State A. Now note, these obligations are not owed to the national of State A. They're not owed to the foreign investor itself. It's owed, those obligations are owed to the state of nationality of the investor. And these are state-to-state obligations. They exist under what we call customary international law. That means the international law between states that is not treaty-based. Next slide, please. Well, this then brings us to investment treaties. Investment treaties are usually bilateral. That means between one country and another, so between State A and State B in my example. But sometimes they can be multilateral. There are examples of multiple states having investment treaties. And Martins will talk about this in relation to the Organization of Islamic Cooperation Investment Agreement, which is a multilateral investment agreement. And sometimes investment treaties are embedded as part of a free trade agreement, like NAFTA, or its continuation treatment treaty, the Canada-US-Mexico agreement, CUSMA. So what these treaties do, BITs and so on, is they take the international law obligations that I've described at the state-to-state level, and they codify them in treaties. They write them down in treaties. So they don't usually create new law. They usually just take the existing law and write them down expressly as state-to-state obligations as to how those states that sign the treaty agree with each other how they will treat nationals of each other's country that invest in their territory. So most investment treaties, and there are almost 3,000, and they're all different and unique, separate treaties. But as a general proposition, they all usually just codify existing international obligations, sometimes with a few changes. But the thing that makes these investment treaties important and unique is that almost all of them expressly allow investors of the one state to start arbitration directly against the state where the foreign investor has made the investment for breaches of the state-to-state obligations that are contained in the treaty. Now, this in international law is remarkable. It's remarkable because states cannot be sued by way of arbitration, first of all, without their consent. So on a state-to-state level, there needs to be consent in a treaty or an express agreement. But certainly individuals and companies can't, at international law, begin litigation against a state unless there's a special provision where this is allowed. And essentially, these investment treaties, most of them provide for the ability of a foreign investor to start an arbitration directly against the country where it has made an investment if the investor thinks that the obligations in one of these investment treaties that flow between the two countries, the country of the investor's nationality and the country where the investor has made the investment. So if the investor thinks there's been a breach of these treaties by the country of investment, there's already a standing open consent by both states to allow the foreign investor to start an arbitration directly against the offending state. And that is unique and important because it doesn't require any kind of contract or direct agreement between the foreign investor and the state where the foreign investor has made an investment. It's just a standing offer by the two countries that have signed the treaty, or the multiple countries if it's a multilateral investment, that they will allow this to happen. Next slide, please. I'm going to give now a very brief history of investment disputes in the Middle East. And these predate investment treaties. As Andrew said, the first investment treaty was in 1957, and the bulk of the most investment treaties have only been signed from the early 1990s onwards. So the most investment treaties are only at most about 30 years old. As you know better than me, arbitration has a long and distinguished history both in the Arab world and in the Muslim world. It's a respected form of dispute resolution, as you all know. In the last 2 or 3 decades, investment protection has become a very important part of the investment policies and the economic plans of many states, particularly in the Gulf region. And so the GCC countries in particular have been very much at the forefront in trying to encourage investment into their countries by, amongst other things, signing up to as many bilateral investment treaties as they can with countries that are going to make from where there are nationals that will make investments into their country, in order to assure those investors that they will have both substantive protections, and I will talk about those shortly, that are contained in the treaty, but also the ability unilaterally and without a contract to start arbitration against the government. And this phenomenon explains in part the increasing interest in the OIC Investment Agreement, about which Martins is going to speak. Next slide, please. There is a long and distinguished history of investment arbitration cases involving the Middle East. And I've shown a few of them here. They started even as early as 1950 with a case between Petroleum Development Company and the ruler of Qatar, and then one against the ruler of Abu Dhabi. And these were even against those countries when they were countries that were organized within protections of the British protectorate system. And you can see the list of cases here. And in each instance, the country that was the target of contractual-based arbitration abided by the rule of law, defended the case, and when it lost the case, each of the countries complied with the award and paid the award if they were required to pay money. And in each case, very righteously, the countries involved followed the rule of the law internationally, and it gave comfort to the countries, to the foreign investors, that even if things went wrong with governments in the Middle East and the Gulf, that the governments would follow their legal obligations in terms of dispute resolutions and outcomes. And this was before investment treaties, but they were investment arbitration cases. Next slide, please. You can see here more examples as time goes by through the 60s, 70s, and 80s of non-investment treaties, but nonetheless investment arbitration cases involving the Middle East. Most of these, of course, revolved around resource extraction, hydrocarbon extraction disputes, but they were very important precedents for investment arbitration around the world. The Middle East really led the way in showing that this was a very effective way for foreign investors to feel comfortable about having the rule of law and internationalized the dispute resolution in relation to the countries involved. This very much contrasted with the treatment of foreign investments in Latin America, where there was a philosophy to try and force foreign investors to go to dispute resolution in domestic courts under domestic laws, which were almost always unfavorable to the foreign investors, which meant that there was a real retardation and slowing down of investment in Latin America, and consequently slower economic development than comparatively in the Middle East and the Gulf. Next slide, please. Now I'm going to look at investment treaties and look at some of the fundamentals of investment treaties in terms of jurisdiction to get protections. So foreign investor to obtain the protections in the treaty, what are those substantive protections and what are the dispute resolution provisions? Now, remember, there's almost 3,000 investment treaties in place now in the world, and more being signed every year. Each one is unique and individual and different. So when we talk about investment treaties, BITs, we're talking in general terms. You need to analyze each one individually. So it's a bit like talking about, say, hydrocarbon or construction contracts. They share the same things generally, but they're not. You can't expect that there's necessarily everything the same in every single construction contract, for example. You need to examine each of them individually. Next slide, please. In order to get the protection of an investment treaty, an investor must fit within the framework of an investment treaty. And there's usually a definition section at the front that explains what is a protected investor and what is a protected investment. And these are Latin terms which are used to describe the main jurisdictional thresholds that have to be ticked before an investor and an investment can be deemed covered by the substantive and dispute resolution benefits of an investment treaty. The first is ratione temporis. That means that the treaty must be signed and enforced at the time of the alleged breach of the treaty in relation to the investment. So if there's an investment made in, say, 1990, and the investment gets expropriated by a government in 1995, and an investment treaty is signed in 1996 and ratified in 1997 between the country of nationality of the foreign investor and the country where the foreign investor made the investment, the treaty has come into force after the alleged breach and the investment, and so there normally wouldn't be an ability of the foreign investor to get the protections and benefits of the treaties. Now, I said normally because, as I said, each of these treaties is different, and there are one or two treaties that give retrospective protections, but you need to read the treaty itself. The second jurisdictional threshold is called ratione personae. That means the investor, the foreign investor, has to be an investor that is protected under the BIT. And again, there's usually a definition of what constitutes an investor. It usually is a human being with a nationality of the country. It's usually a company that's incorporated in the one of the signatories to the treaty. But sometimes it's more than that. Sometimes any company that operates using a branch office from one of the countries that signed the treaty can be protected. Or sometimes even a company that's incorporated in the country will be required under the terms of the treaty to be more than just a post box company, but have active operations in the country of origin before it gets the benefit of the treaty. So you need to look at that. And then ratione materiae, you need to look at the type of investment, because again, not necessarily every type of investment is covered by a treaty. So for example, the investment treaty between the United States of America and Azerbaijan specifically excludes any investment in the energy sector. That's just the hydrocarbon sector is just expressly excluded. And so there'd be no coverage under that treaty for an investor incorporated in the United States of America that made an investment in Azerbaijan, unless that American company set up a branch plant or a subsidiary operating from a different country that had itself an investment treaty with Azerbaijan, and that subsidiary company could make a claim against Azerbaijan if there was no similar carve out of the treaty by Azerbaijan. Next treaty, please. Sorry, next slide. Yeah. So the key sorts of protections you usually find in most investment treaties are as follows: a protection against expropriation without compensation. So in international law, expropriation is legal, but it has to be accompanied by appropriate, prompt, and adequate compensation. So the money has to be market value, et cetera, et cetera. But again, sometimes there'll be a definition of compensation in the treaty that's different from market value. You need to look carefully. What's called fair and equitable treatment is also covered, which means transparency, not whimsical regulation out of nowhere. Then there's usually most favored nation protections in a treaty, which means if one of the parties to an investment treaty has an investment treaty with another country that gives even better protections than in the bilateral investment treaty between the first two countries, those substantive protections will be imported as if they were in that original BIT. And then national treatment. Usually it's embodied in the treaty that a state can't treat a foreign investor any less favorably than its own national. So it can't discriminate in favor of its own nationals in its regulation of the economy. These are the sorts of key substantive legal protections that are usually in most investment treaties. Next slide, please. So dispute resolution. As I said at the outset, the magic, if you want, of most investment treaties is that they allow a foreign investor from one party to pursue dispute resolution, including arbitration, directly against the host state. It's effectively, although not precisely, it's effectively an agreement between the states to allow subrogation of their own rights to the foreign investors. And there doesn't need to be a direct relationship between the foreign investor and the offending state. And there's a number of administrating bodies, ICSID, PCA, and there's some exciting developments at the OIC that I know Martins is going to discuss. Next slide, please. So very quickly, the current era of modern investment treaty arbitration in the Middle East. Next slide. Increasingly, there's been more and more investment treaties signed in the Middle East. There's been more and more foreign investment in the Middle East, and consequently, there's been an increasing amount of investment treaty arbitration in relation to the Middle East. I described earlier that there's almost 3,000 investment treaties globally, and they often exist with multilateral treaties. And again, Martins is going to talk about the OIC. Next slide, please. You can see here on this slide a coloring of from lighter blue to darker blue, the Middle East region, showing how many investment treaties have been signed by countries in the Middle East. Egypt and Kuwait have many. They're very dark colored. Jordan has a reasonable number of them. I had a successful case for a foreign investor against Jordan. And Qatar has 65 investment treaties. Next slide, please. This is a list of the BITs that Qatar has signed around the world. You can see starting in 1996 and leading up to as recently as last year. So there's quite a lot of protections for foreign investors investing into Qatar, but also vice versa. And this is, next slide, this is one of the phenomena I'll be talking about at the very end. There's been an increasing number of investment treaty arbitrations involving Middle Eastern states as defendants, including Gulf states. But there's also been an increasing number of Middle Eastern, particularly Gulf investors investing overseas, who are realizing that they have protections and that they can sue foreign governments when they've been expropriated or their property's been interfered with. Next slide, please. Currently, there's an increasing arbitration-friendly environment in the Middle East, including in the Gulf. I'm sure you're aware of this more than me. ICSID, which is the World Bank's Institute for managing investment treaty arbitrations, administering the arbitrations, has seen over the last couple of years an increase, a significant increase of the number of investor state arbitrations that involve the Middle East. As you can see, it's very much growing. Next slide, please. There's been a number of very recent examples of pro-foreign investment arbitration enforcement in the domestic courts of the Middle East, particularly in the Gulf region. There's an example here from Dubai. Next slide. There's an example from Saudi Arabia. Next slide. So what does the future hold for investment treaty arbitration as I wrap up my presentation? Next slide. I predict more and more investment treaties signed by Middle Eastern countries, particularly the Gulf, as the Gulf countries seek to transform their economies into a post-hydrocarbon energy economies, and they require foreign investment and foreign cooperation and so on. And as they want to encourage outflows, protected outflows from the private sector in the Gulf particularly. So there's been a proliferation of investment agreements, but also in arbitration disputes involving nationals or governments from the Middle East, particularly the Gulf. These sort of disputes are not bad, because when a government complies with the outcome of an arbitration, it shows the world publicly its commitment to the rule of law, and it encourages foreign investors, rather than discourages them, to think, well, this is a place I should invest because I have the protection of the rule of law. Next slide, please. So again, here's an example of a recent investor from the Middle East, particularly the Gulf region, that used the OIC agreement to protect his investments in overseas, and this was in the Republic of Indonesia. And I'm sure Martins will address this phenomenon. Next slide, please. So there's some key arbitral institutions and legislation that's coming out, including in relation to Qatar, that will support investment treaty arbitration. Next slide. And that brings me to the end of my presentation. Thank you all very much for your attention, and no doubt there'll be some questions and discussion at the end. I now hand things over. Thank you very much for your attention.
Thanks very much, Robert.
Andrew,
yes.
Can I
Sorry,
interrupt for a
yes,
second?
please.
Can I ask the attendees to address their questions in Q&A, because I've seen some questions has been asked. So please write it down in the Q&A so we can gather it at the end of the session. Thank you so much. Sorry to interrupt.
No, that's. I was just going to say we'll have a few questions have come in, and so we'll consolidate those at the end. So yes, moving on to to Martins. Martins, if you would like to take the floor with your talk in relation to the Organization of Islamic Cooperation Investment Agreement.
Thank you, Andrew. Let me just begin by thanking the organizers for inviting me and you for the very kind words of introduction, and in particular, Nurul and Ciarb for impeccable organization of this, as well as I have learned a line of stellar earlier events. As I proceed, let me open my slides. Now I'm in a rather fortunate position that you have already been told all the key important things about investment law and investment treaty arbitration, so I can dive into one of the more particular questions that has been mentioned a number of times by Robert, the Organization of Islamic Cooperation, that I will refer to as OIC Investment Agreement, and the settlement of investment disputes. And I propose to address it in 5 steps. First, unsurprisingly for an introduction, introducing the concept of the OIC Investment Agreement, then giving an overview of investment disputes. In the 3rd and 4th part, and that will be really the core of my presentation, looking at certain particular jurisdictional and substantive aspects. I think here, as we heard from Robert, every treaty is particular in its own way. We have to pay careful attention to the drafting, but I think that the OIC Investment Agreement is particular even against that background. So there will be some particular chestnuts that I would like to unpick with you. And finally, in conclusion, I will speculate and make some suggestions about possible future for investment arbitration and more generally investment dispute settlement under the agreement. The first part of my talk will introduce the investment agreement. Now, one thing to note about the agreement is that this is somewhat atypical in terms of time of adoption. The OIC Investment Agreement was adopted in 1981 and entered into force in 1988. And that puts it as one of the older investment treaties currently in force and, as it were, actively being used in practice. It is common to think of investment treaties as falling in a number of generations. So a couple of hundred investment treaties are concluded during the Cold War. Then, I suppose, the classic investment treaties concluded after the end of the Cold War in the 1990s, with general endorsement of the Washington Consensus in the practice of states. And after the first investment arbitration started coming out and elaborated both the challenges and promises on investment treaty arbitration, from early 2000 onwards, one might say, states have been continually refining treaties by reference to challenges identified. OIC Investment Agreement was concluded and remains expressed in the textual form from before all that. So when we read the treaty, when we read cases associated with the treaty, the very interesting challenge that we face is squaring, on the one hand, the instrument itself, which probably treaty interpretation requires us to read as it would have been understood by a contemporaneous international lawyer of early 1980s, but on the other hand, also reading it with a certain eye to challenges raised by the more recent cases. So that is an interesting challenge, and it may be that some tribunals have grappled with that challenge better than others. So this is a time period of 1980s where many of the modern challenges and procedural queries had not yet arisen. But I would absolutely want to endorse Robert's broader point repeated a number of times about the importance that region, the Middle Eastern region, has played in the foundation of investment treaty arbitration, sometimes in an appreciated manner, sometimes in an unappreciated manner. So, for example, one point that has been recently uncovered, or at least publicized by scholars, including some of my colleagues, is the Euro-Arab investment treaty that was almost concluded in the mid-1990s between the members of the Arab League on the one hand and European Economic Community on the other hand. It faltered, even though it had been legally almost finalized due to the politics of the mid-1980s, but certainly presents a fascinating glimpse of investment law as it might have been if it had been shaped by that treaty. And of course, the very first arbitration without privity, arbitration in that magic that Robert referred to it, where an investor accepts an open offer expressed in an instrument, a statute, in that case, treaties more commonly and more recently, by launching a claim. So that was a case where Egypt importantly challenged the proposition that it had expressed consent in the particular statutory instrument, but led by the great and late El-Kosheri, did not challenge the underlying principle, and therefore, by implication, accepted it, giving the way to the acceptance of arbitration without privity in treaty arbitration a number of years in APL and Sri Lanka, where the same El-Kosheri was one of the arbitrators. So investment arbitration has a long and glorious history in the region, even if sometimes not fully appreciated. What is a treaty? So the basic bones are in the treaty membership. I have to say that on many of these propositions I make about the treaty, you will see qualifications, supposedly or allegedly, and sometimes sneaky question marks on certain statements. The reason is that it is less possible, perhaps, to say with certainty the legal position regarding certain matters regarding the OIC treaty than regarding other multilateral and bilateral instruments. The treaty is not entered in the United Nations Treaty Series. It does not have a dedicated website for more than its text. Other multilateral instruments, for example, the Energy Charter Treaty, has a dedicated website with the list of parties and cases brought under the instrument. So we do not have that for the OIC Investment Agreement. And there may be, as it were, we always, when we discuss these matters, there may be more to this than catches the eye. There may be the known unknowns, cases that have been litigated, but that have been litigated in a confidential manner, and that have not been brought to our attention through the usual means of publicizing investment by review proceedings in domestic courts or attempts at by enforcement. But having said that, OIC member states in the number of 29 have ratified the agreement, and that is an important legal proposition. Unlike the bilateral treaties that have obligations running only between their parties, this suggests that investors from any of these states can sue any of the other states, as it were, any states for which they count as foreign. Therefore, counting really in terms of numbers, having the same effect as hundreds of investment treaties. So extraordinarily powerful proposition in terms of personal scope. The large general point to note is that authentic languages of the treaty are Arabic, English, and French. And the Vienna Convention on the Law of Treaties, in Article 33, that speaks about interpretation of multilingual treaties, would require us taking into account all the authentic languages of which none has been identified by parties as a priority. And that, I think, is something that gives a bit of a positive strength to those of you who are multilingual in all of these languages, therefore being able to rely on all these texts. In practice, I have to say that mostly tribunals have relied more on either the Anglophone or Francophone versions, depending on the forum in which they are litigating cases, whether it's something that is being reviewed by French or English courts. But as a matter of legal proposition, Arabic operates at the same authentic level and should carry the same way. So that is by way of general introduction. An important treaty, an old treaty, an interesting treaty, a multilingual treaty. Also, arguably a forgotten treaty. Since 1981 until 2011, it apparently had not been relied publicly in investor-state arbitration. Now, it doesn't mean that it hadn't been used by investors in negotiations. Investment arbitration is something that is, of course, a powerful instrument of dispute settlement, but it is also a powerful instrument for throwing the shadow of law in the negotiations between investors and states. So it may well be that this is something that parties and their advisors were familiar with, but that was simply never brought to the light of the day. And of course, as I said, because there's no dedicated website, there's no automatic system of publicizing the decisions, it may well be that there are things that have happened that we simply do not know about. But 2011 and subsequent years was the beginning of the general public engagement with these matters, starting with the case that Robert mentioned, Al-Warraq and Indonesia, introduced in 2011, and jurisdiction confirmed in 2012. You can see on the slide states that have been involved as respondent states in these disputes and investors from the countries that have brought the claim. And the Venn diagram suggests a somewhat but not completely overlapping claim, which is often thought to be viewed as a healthy aspect of investment law. That is not this balance that certain countries act only as respondents and certain countries act only as claimants' home countries. All countries are appreciative of both the risks of exposure as respondents and the reported benefit to investors to be capable of launching the claims against other states. The sectors is, I would imagine, what one would expect arbitration and dispute settlement claims to be about. Construction is a key aspect, together with natural resources, and a couple of cases have related to more discrete economic sectors like banking and transport. You might be surprised, because I said that the modern public OIC engagement started more than a decade ago, that these are still early days, but they are still early days. 4 cases have been concluded, 2 in favor of the state, 2 in favor of the investor, but it is fair to say, as you will see in the next slides, in neither of them did investor have the reason to feel elated by the result. In one of those, the Al-Warraq case, liability was found, but no damages awarded. In another case, damages were awarded, but they were greatly smaller than the claim suggested. But these are still early days, and that, I think, would be really my key point when one might think, looking at the decisions so far, that OIC is not really much to write home about. More cases are pending that have been decided, and so we simply do not know yet where the, as it were, the brunt of the decisions, their general effect falls. Certainly, states have taken seriously and been fairly successful in defending their claims. So that is also something that speaks to the sophistication of actors in this setting. Looking at the particular aspects of jurisdiction and substance, and so that is something that I will go to next, it seems that because of its slightly aged nature, the treaty has raised unusually hard questions of jurisdiction and procedure, particularly regarding the completion of constitution of arbitral tribunal, while conversely on substantive matters, less unique questions have been raised. So in short, important early days so far on the scorecard, states doing well, investors doing less well, but early days and still raising interesting and hard questions of applicable law. Let me give you a number of examples just so for a sense of what sort of things and what sort of legal questions arise. The first case is Al-Warraq and Indonesia, a case regarding a banking claim where the investor alleged that Indonesia's detention and prosecution of the investor in relation to conduct regarding the bank was in breach of the agreement. So in an important jurisdictional decision that was, I suppose, pretty much the decision that alerted the broader arbitral community of the potential of the agreement, the tribunal concluded that it had jurisdiction and that Article 17 of the agreement operated as a traditional arbitration without privity consent, to which investor provided its half of consent by bringing the claim. On the merits, the tribunal found that Indonesia had breached fair and equitable treatment in its criminal justice conduct regarding the investor, relying perhaps in the view of some somewhat strongly on international human rights law, read in through the International Covenant for Civil and Political Rights. But no damages were awarded because the tribunal found a variety of breaches of domestic banking regulations, and so dismissed that part of the claim, building to some extent on the general principles of unclean hands, to some extent on the specific language in Article 9 of the agreement regarding the obligation of compliance with domestic laws. So, claim regarding an important sector, important conduct in criminal justice, admissible and found justified, but because of the misgivings regarding conduct of the investor, ultimately not run through. The second case is the one where the investor did get a certain monetary reward, but it was minuscule compared with the award actually claimed. So this was essentially the focus was on the conduct of the state, or actually one might say the lack of conduct, the omission in the negotiations of a contract with the investor. So very significant breaches were found, but the tribunal concluded that the major part of the argument relating to the lost profits that would have arisen under the new contract, causality chain was broken. Therefore, only a comparatively small amount was awarded, and the investor's attempt to set it aside was unsuccessful. And probably the most interesting example is the DS construction FZZO CO against Libya, where Libya refused to participate in the appointment of the arbitral tribunal, the Secretary General of the OIC that appears to have the function of stepping in as the appointing authority did not exercise its function, and the attempt to rely on the PCA Secretary General for that, while approved by the tribunal itself, was not accepted by the Paris Court of Appeal, raising the interesting question to which I will turn in a second about the effects of the failure to participate in the constitution of the tribunal by the respondent, whether that is ultimately justified in terms of procedural tactics position to take. So what are the issues arising, particularly regarding jurisdiction? And here I would like to focus in particular on three questions. The first is whether Article 17, the article of the treaty that provides for consent, provides for reference to arbitration, does provide unconditional consent by the state to arbitration. Because remember, my initial point, this is a treaty from 1980s, where states were often much more cautious, much less clear in expressing their consent. And so in the first case, in Al-Warak case, Indonesia argued that this was ultimately not unconditional consent. And if you look at the language, it does seem that there are pointers pulling in one direction as well as the other. So in the chapeau, there is a reference to disputes being settled through conciliation or arbitration. Conversely, the highlighted portion in the second paragraph regarding arbitration does seem to subordinate arbitration to reliance on conciliation. And Indonesia's argument, which I think was a perfectly plausible one to make, even though it was rejected, was that to the extent that conciliation depended upon a consent which will not be provided, one never, as it were, reached the arbitral level. So that argument was rejected, and the tribunal spent quite a bit of time looking at the broader structure of the agreement and various language versions before concluding that consent had indeed been provided. And that appears to be the position that has been taken by other tribunals as well. Now, the interesting question, I think that this is something as practitioners you will certainly appreciate very much. What happens if a party does not fully participate in the constitution of the tribunal? In particular, what happens if the respondent does not nominate an arbitrator? In some cases, that is not an issue that has arisen, but in some cases it has arisen. And Libya in particular has decided rather not to participate in the proceedings and not to appoint arbitrators, not because of unfamiliarity with investment arbitration. Libya is a very sophisticated litigator, and indeed in parallel BIT cases has appointed arbitrators, but it has taken the view that the treaty does not provide for arbitration, and therefore it will not even dignify it with participation. And for reasons that are not completely obvious from the outside, the Secretary General of the organization has not stepped in to complete the composition of the tribunal. Partly, I understand the argument goes due to the lack of time limit provided for in this setting. Now, one argument that parties have raised, investors have raised, and that tribunals have partly accepted, is that in such circumstances, it might be possible to rely on the PCA Secretary General as the authority, as the appointing authority of the designating authority, as if it were an ancestral case, even though it is not ancestral, but a general ad hoc arbitration that is provided. Tribunals have been mostly favorable to this view, and you can see the list of the decisions on the screen, but importantly, the Paris Court of Appeal has not. So it has concluded that ancestral has not been provided in the treaty, so you cannot rely on a procedure for completing a tribunal that is different from the one that has been provided. So there's a question mark about the safety, as it were, of those proceedings that are taking place under French applicable law in the French seat, to which this principle would be applied. So this is one of those to be watched for the future. Similarly, there's an element of uncertainty regarding the applicable arbitral rules. The treaty itself, as you see from the quoted part of Article 17, is a bit sparse regarding rules that are being provided. Parties can, of course, agree for rules to be applied, as they did in Al-Warak regarding ancestral, upon the initiative, indeed, of Indonesia. Sometimes parties have relied on most favored nation treatment arguments of trying to bring in the arguments, procedures from other treaties with mixed results, as you saw from the effect in the Paris Court of Appeal, and attempts to rely on ICSID have been unsuccessful. So I think, again, we see here the tension between the modern developments in the field and the need to be faithful to the textual expression of the drafters in 1981 to the extent that they have not departed from it. In terms of substantive rules, I have to say here the rules, while expressed perhaps in somewhat archaic language, are substantively effectively analogous to rules in modern treaties, full protection and security, mostly from attacks by third parties, and compensation for expropriation. To the extent that rules are not provided in the treaty, our Warraq Tribunal has accepted reliance on the most favored nation treatment clause to read in these rules from other treaties, so fair and equitable treatment, for example. There is an ongoing, rather fierce debate on the extent to which MFN treatment can operate in this manner, but so far within the OIC, it seems to have been accepted. And in the Al-Warraq case, the tribunal relied quite aggressively on the International Civil and Political Rights Covenant to interpret and apply the treaty, going perhaps somewhat beyond the jurisdictional mandate in the classic sense. So that really brings me to the last point here, Article 9, the as it were, the grave man of Al-Warraq's claim due to the breach of banking rules, with really some uncertainty. So clearly it has some legal relevance, but there is ground for reasonable disagreement of whether that only, as it were, reflects the basic idea that non-state actors have to comply with laws, or whether that makes such a broader point as Al-Warraq concluded. So what about the future? And this is my last slide, and we'll be just really passing on shortly to the organizers. There are certain interesting questions that we have to keep in mind when thinking about the future. Probably the most contentious ongoing question is regarding the completion of the arbitral tribunal. Is that something that is respondent state wise to take the risk of not participating at all and hoping that the reviewing authority would take the position of the Court of Appeal in Paris, essentially that this is an ultimately uncompletable tribunal if parties don't participate in, or whether it is wiser to do it through participation. The French position, at least for the moment, seems to be that a non-participating respondent is acting wisely. The position of London and Swiss courts is unknown for the moment. And I think a great deal also turns on how we interpret the most favored nation treatment. What for the future? And here, I'm sure that many in the audience will be more knowledgeable on these matters than I am. It is certainly the case that these are matters that are being discussed in the OIC. You may recall, let me just jump back to whenever I have Article 17. If you look at the very top, so the very first part of the sentence before the underline, until an organ for the settlement is established. And so the argument would be that to the extent that it is established, everything that we have discussed so far is falling away. And there have been public announcements that parties are discussing it for the last couple of years, albeit no public texts or indications of the time of their completion have been provided for. And parties have also provided an OIC arbitration center that operates in Istanbul with the purported purpose of working on commercial and investment arbitration. So this, I would say, is probably the space to be watched argument, albeit with uncertainty of what precisely and when precisely that space will be filled with. And that concludes my presentation. Many thanks. Back to you, Andrew.
Thank you very much, Martins. Right, so we've got two concluding parts to today's proceedings. Firstly, the question and answers, and then a presentation to conclude at the end from the president of the Chartered Institute in Qatar. So I've tried to consolidate the various questions that are being asked through the chat, and I suppose, well, a first and quite easy one to both to Martins and to Robert is there are two questions here relating to where can information be found. I must say it is often difficult to try and locate where there may be records of the disputes, particularly obviously as arbitration is private. So perhaps Martins, you may be able to answer that one. As far as our attendees would like to do their own sort of researches, where could they find the case reports in relation to these matters?
That is a great question, and ultimately I do not have a very satisfactory answer. It depends on a great deal on the approaches and applicable rules of the particular arbitral institution. To the extent that cases are brought to ICSID, the International Center for Settlement of Investment Disputes under the World Bank, if the audience just types in ICSID in their web browsers, it would pull up a fairly sophisticated website that has advanced information about cases being registered, decided, arbitrators, counsel, and economic sectors, and an obligation on the Secretariat to publish ultimate decisions with consent of parties, or at the very least, legal excerpts of those decisions. So to the extent that something goes to ICSID, there's a great deal that can be glimpsed. It is harder with other institutions. Permanent Court of Arbitration, that also handles a large part of investment arbitration work, takes a more classic approach to confidentiality and publicizes information and decisions to the extent that parties have agreed to that, or there are any transparency rules applicable. And if we look, say, at the last year's list of cases, we know simply by looking at the case numbers that there are cases that would be in the high 40s, but only 5 investor-state arbitrations are publicly available, even in terms of, I guess, a dedicated webpage. So there's a great deal of known unknowns. We know that things are going on. We also know that probably about 9/10 of them will only be merging eventually in the usual way how we learn of arbitrations through review and set aside. And to the extent that things are being administered in a completely ad hoc manner, that is even harder to predict when and where they would come out. There are dedicated, as it were, albeit paid information sources. Global Arbitration Review is one, investment arbitration reporter is another one, finding and searching for information and to the extent possible for decisions. But so I think probably one needs to sort of have the mental map of the variety of ways how information could seep out and approach it with a due sense of skepticism that the information out there is the entirety of information that we want to be out there.
Yeah. Robert, I don't know if you have anything you'd want to add. I'll perhaps direct the next question to you after that.
Sure. I mean, I agree with what Martin said. Just like everybody on this in this meeting will know from their own practices in commercial arbitration, there is no full transparency. There's a lot of opaqueness, and the art in investment treaty arbitration is being sufficiently on the inside, sitting as arbitrator, being counsel, advising governments, drafting investment treaties, and so on, to know what's actually going on. ICSID, the ICSID rules and convention, prohibited the ICSID Secretariat from publishing the awards. ICSID has been in a bit of a competition with the Permanent Court of Arbitration to be the administrator in arbitration cases, and for reasons best known to ICSID, they decided to ignore the rules and convention, and as Martin says, what they call publish excerpts, i.e. breach confidentiality obligations, in order to in their view, try and get better market share of cases coming to them. That's a crass and simplistic but real view. The reality is that most investment treaty cases get published in one way or another, but one has to be careful about GAR and other sort of vanity press, because what people say they won, GAR just publishes. They talk to the lawyers, and each lawyer says, "Oh, we won a most amazing victory because whatever." You've got to be quite careful. Read the actual award if you can, or try and read credible sources about them. There are a number of academics who write articles that have compendia of data and so on, and can be deemed perhaps more reliable sources. But probably most investment treaty disputes actually are resolved before they ever get recorded anywhere, either by being registered at ICSID or otherwise, or by having an award outcome. I know, for example, in my experience, I've settled far more investment treaty disputes than I've arbitrated. That's just the reality of things. As Martin said about the OIC, it's difficult to tell what effect it's had, but it's most likely been quite influential in foundational discussions about rights and obligations of treatment and compensation between investors and governments that you'll never see a record.
Okay, a couple. Two questions which I'll again consolidate into one and maybe put it to you, Robert. And I think it's a relatively straightforward answer, though I suspect the reasons for the questions are because of some of the difficulties in the Middle East regarding the incorporation of arbitration clauses. So there are two questions, but as I say, I'll consolidate in one, and that is, insofar as your contract, or the contract between the private investor and the state or the other entity, does not actually include an arbitration agreement, does that prevent you from bringing a dispute pursuant to the appropriate investment treaty?
Well, thank you for those questions, whoever put them. They help frame a discussion that allows some clarification around that very important issue. In dispute resolution provisions in contracts will inevitably be based either in a domestic legal system or with reference to some kind of lex mercatoria, sort of general principles of commercial law, or that sort of thing, which are derivative of domestic legal systems. Investment treaty disputes under public international law are always public international law disputes, and always governed by public international law, even when there's some peripheral reference to domestic law for some reason or another. So there possibly two coexisting parallel dispute resolution options available to an investor. If the investor has a contract with a state or a state entity or something like that, it may say, for example, you can arbitrate at the International Chamber of Commerce. And there may be an investment treaty between the state of nationality of the investor and the state where the investment was made, which provides, let's say, for ICSID arbitration. Those are two different governing laws, if you want, for the dispute, and two different dispute resolution procedures. And they exist separately and can be accessed separately, except that many, but not all, investment treaties have provisions in the dispute resolution area which provide that either the foreign investor has to exhaust certain kinds of local remedies, so might have to go to local courts before going to arbitration under the investment treaty, or might require the investor to choose between either domestic remedies or remedies under the investment treaty. And once that decision is made consciously or unconsciously, the investor has to stick with it as far as the investment treaty is concerned. Investment treaties don't cover disputes between two private entities. If one of the entities is a state company or something like that, then there are complex issues to determine whether the company is actually acting as the state or as a private entity. We don't have time to talk about that now. But if it's just between two purely private entities, there's no way an investment treaty really would cover that dispute. So it's really just between a foreign investor and either the country where the investment's been made. So either the government or the police or the courts or something like that. Sometimes also a government-owned company. But again, it depends whether it's acting as a commercial entity or not. So I hope I've answered the question. I'm sure Martin has a few things to add.
Martins, would you like to just add something?
Right. Well, I mean, I agree with everything that Robert said. I think that is a right answer. I mean, I think that as always there could be, small peculiar situations at the edges. So a question of whether an exclusive forum selection clause in an underlying contract affects the capacity of the investor to bring a treaty claim. So states often argue that if an investor has committed to settle disputes in a contractual forum, therefore the treaty forum will be precluded. And there, I think that the answer to that argument is implicit in what Robert was saying. There are different applicable laws, different legal standards, different parties, to the extent that the treaty doesn't explicitly coordinate it for the purposes of international law, domestic law, and domestic forum is a fact. So that does not preclude it, unless there are certain particular obligations that interlink the treaty with the contract, and then the position may be a more complicated one. And of course, the contract might be important in other ways. Contracts might themselves be investments, so objects of protection. So it may be crucially important what the balance of rights and obligations is, what the fair market value is, and so on. And I think a couple of investment arbitration awards have been set aside precisely because they over-focused on the international law perspective and underplayed the importance of looking at what the object of the protection and what the precise injury and causality, as it were. So international law is important, but it has to be applied with a careful eye of the underlying commercial and business realities and the domestic law as well. So it's these are distinct things, but not unrelated things. That is, I think, really the fascinating point of practice here.
Thank you very much. And I think perhaps as one last question, which we've got time for before closing remarks, and again, it's to both of you, and it's at a relatively high level, and I hope I've understood the questioner's question accurately. But that is whether in your experience, both of your experiences, there's any learning that perhaps governments can take as to how they might adjust their behavior to both minimize the claims that are brought against them. And I suppose the corollary of that is how might they encourage more international investment by behaving in a way that is not going to result in disputes. Presumably, in your experience, you've seen certain things that governments do, which inevitably draws or results in a dispute of some sort. Any thoughts there on how governments might adjust their behavior for the future?
Well, I'll jump in and give Martin the last word. The quick answer is yes, there are. And well-advised governments consult experts like Martin's, when they are contemplating certain kinds of regulatory reviews of economic activity or sectors. So if a government is thinking, for example, well, we would like to change the domestic ownership component of electrical energy generation or distribution, for example, or something like that. There are many issues a government has to consider: economic, policy, international relations, et cetera, et cetera. But if they're well advised, they will also consider their obligations under public international law in terms of treatment of foreign nationals, and any obligations they have on specific in investment treaties. So if they know that half of the investors in the sector come from a country with which they have a BIT, they should be informed by an expert that, well, you should expect that if you dramatically change this without engaging in dialogue with the foreign investors, you may be faced with a raft of claims under this treaty. So the answer for the state is not to complain, not to pretend they're not obligated under the treaties they signed or otherwise under public international law, but to manage the regulation of the economy. There's nothing in investment treaties that actually prevents governments from regulating the economy. It's just that in certain circumstances, they have to pay for that. And why is it strange or a bad thing that if a government wants to do something with other people's property, that it pay for it? If, for example, the viewers, participants today, own a house, and if the government in Qatar decided it wanted to build a highway that ran along where their house was, I imagine that most people would think, well, I'd rather not have my house taken and bowled over and a highway built here. But if it has to happen, okay, I'd like to be compensated for it. And that's not unreasonable. That's a sort of a gut reaction, right? That the government, the investment treaties do not prevent governments from regulating the economies as they like. But a government has to be aware that its regulation comes possibly at a cost. And the easiest way for government to deal with this is to engage in dialogue with investors, foreign investors, if they're going to do some dramatic change in a particular sector, and try and get inputs and not dissuade the foreign investors. Some people say that investment treaties stop governments protecting the environment, for example. But if you look at every single investment treaty claim of which I am aware that deals with a government's changing of economic regulation or possible expropriation in order to protect the environment, it's always where, if you look at the facts, the government has actually not just regulated for the environment, but actually taken the entire investment. So the investors lost everything. It's not like they've had an extra cost put on them or an extra environmental tax, but it's basically the government's taken directly or indirectly the entire investment and given them nothing back. You don't see investment treaty claims where an investor is required to put an extra screen on a smokestack or try and use less carbon fuel, these sorts of things. So governments can and should be much more sophisticated about these things. And the last thing I'll say is, as I mentioned, I settle more of these things, whether acting for investors or governments, than I litigate these things. And that's because governments are enormous enterprises and they can't consider everything all the time. And there are many occasions where a government regulates the economy, passes some law, and it doesn't intend to expropriate or very significantly damage the foreign investment, but it happens to do so. And most governments don't want to dissuade foreign investment, don't want really to take over foreign investors' property unintentionally. Sometimes they do, but usually they don't. And most foreign investors aren't in the business of making money from litigating against governments. So there's usually a win-win outcome if there's dialogue. The danger is if government officials, or in democratic countries, a government is mindful of an election coming up and thinks that it would appear weak if it negotiated an outcome. That's where there's danger, when a government gets entrenched in a silly position. But if a government is sensible, let's say it passes a regulatory law, doesn't intend to, seriously harm a foreign investor. Foreign investor says, "Oh, you may not have realized, but you actually have now, almost taken away my entire investment." There's always a sensible outcome that can be arrived that the governments are well advised to pursue.
Thank you, Martin. So, got a couple of minutes. Yeah.
Right. And I mean, I think that there's nothing that I heard that I disagree with. I mean, probably the one thing that states can think of is, I suppose, precisely as regarding any other litigation risk, setting up a domestic institution that would be able of managing these matters if claims come in precisely in the same way as states would manage have a dedicated office that would deal with claims against the state in constitutional or administrative or regional courts. I think that is really, a seemingly simple thing, but, in a sense, a certain office to which the notice of the claim needs to be sent, that has the constitutional capacity and political support to bang people's heads together and get the evidence out of dispersed different ministries, regional units, state-owned enterprises. As the practitioners of arbitration will know, the first months will be crucial. Gathering evidence, under the unforgiving schedule of UNCITRAL rules, already getting in the appointment process. So it's important that, I think really the combination of foreign experts who are experienced in litigating, but it's hugely important to have a domestic structure, as it were, which fits together with all of that. I mean, I think also the one thing that I would like perhaps to add is that I think Robert is right. Many of these things can be simply internalized in the rulemaking process in precisely the same way as one would do with anything else. Simply checking whether this raises issues under this body of rules, just as it would raise issues under other bodies of rules. And I mean, again, treaties are made by states, they may be changed by states. If states conclude on balance that they are unsatisfied by the costs imposed and that they don't see enough of a value for their investors and broader policy, they may renegotiate, they may impose more severe restrictions. And that is, I think, what has been suggested OIC is thinking through with establishing of another body. So I think probably one can sort of put the 90% of cases that arise in the routine operation of the government, where I would tend to agree with the way how Robert described it. And then there are some that raise particular challenges. And I think in the Middle Eastern sector, a region, there have been cases against Egypt and Syria that raise questions of security policies and protection in civil wars and military conflicts and against terrorist attacks, which it's not insensible for states to feel that on balance we feel slightly squeamish to have to engage in detail in these matters. And I think climate change, it is fair to say that this is a point on which reasonable people will disagree. We will all be aware of the importance of the legislative and international changes. There are many states in the European setting that feel that investment law is in a bit too much of a tension with climate change law. It might not preclude it, as Robert said, but it certainly does not make it a smooth and easy endeavor. And again, ultimately, it is a policy choice. I think that a great deal can be dealt with by good negotiating and good litigating, but ultimately, if advised by competent advisors, states conclude that it's a bit too much, that is also a perfectly fine solution. So I think, probably not, I think treaties have a long shelf life. They are not easy to get in traction and they are not easy to get out of. So that is certainly not something that is around the corner, but kind of the big picture, the states should certainly also be thinking about that. So that I think would be all for me.
Thank you very much. So I'll leave it to Ciarb to conclude now, but from a personal point of view, thank you very much for both of you, Robert and Martins, for your contributions. Ciarb, over to you.
Thank you so much, Andrew, Robert, and Martins. Actually, investment treaty arbitration was always some kind of dark area for people who are practicing arbitration in general. And actually, when I first listened to Robert, I think 6 months before, and I thought that we have to bring him to this platform to let more people understand and get more knowledge from him and Martin's as well. So this actually was being prepared for a long time, and I'm happy that we finally made it here, which I'm seeing from the number of the attendees and people questions that they would like to know more about it, which is I'm really happy that we brought the attention to such a subject. I understand that many of the practitioners are not practicing this specifically because it's very niche, I would assume, an arbitration practice. That's why I'm extremely happy that we hosted Robert today and Martins, with the support, of course, of Andrew, that we were able to manage a successful, I would say, webinar with the number of attendees and the questions we have. So thank you so much for the attendees who came to listen to us, and thank you so much for the speakers, which is, I know that their time is very valuable, and show generosity to come and deliver such a voluntarily webinar to us, and the moderator. Thanks to my colleagues behind the scenes, Tamer and Nurul, of course, for wonderful organizing. And I would like to say something before we conclude, that we are now preparing our annual general meeting and the first conference for the Ciarb in Qatar. It's going to be on 9th of May. We will be announcing this very soon. So please wait for the upcoming news. Inshallah, we wish that we can have a successful conference in the future. Thank you so much. And again, I cannot thank you enough. And thanks everyone today. We will be sending the slides to people who attended and not attended, with the permission of the speakers as well. And see you next time. And happy Ramadan, everyone.